Thank you very much for attending HRSA's third Risk Management Audio Conference of 2011 titled Shoulder Dystocia, Managing Clinical and Legal Risks. My name is Kate Reback, and I'm with the Office of Quality and Data in the Bureau of Primary Health Care here at HRSA. We are pleased that you have been able to take some time out of your busy schedule to join us for this timely and important audio conference. Today's presentation is the third in a series of risk management audio conferences designed to assist you in developing a robust yet user-friendly clinical risk management program in your health center or free clinic. We at BIPIC are committed to supporting your efforts to deliver quality health care to your patient population. To that end, we have been busy working with our partners, Health Management Solutions and ECRI Institute, to provide you with various quality, risk management, and patient safety guidance and resources to help you achieve this goal, such as today's audio conference. Without further ado, I would like to turn the program over to Mr. Paul Anderson.
Thank you very much, Kate, and welcome everybody. As Kate said, I'm Paul Anderson. I'm the Director of Risk Management Publications here at ECRI Institute. I'd like to start by introducing HMS, or Healthcare Management Solutions. HMS provides services for HRSA's FTCA claims review program, including focused medical reviews, data analysis and trending, coordination of services, with the goal of improving clinic performance and claims reduction, and risk management resources and services through ECRI Institute. ECRI Institute is an independent, nonprofit, applied research institute, and over the past 4 decades, we've helped thousands of healthcare organizations across the nation develop patient safety, healthcare quality, and risk management programs to improve patient care. Our 350-person staff is made up of physicians, nurses, patient safety, risk management, and quality professionals, clinical engineers, and more. We are an evidence-based practice center designated by the U.S. Agency for Healthcare Research and Quality, and we're a federally designated patient safety organization. Nearly 3/4 of all HRSA grantee organizations throughout the country have now activated their user IDs and set up passwords so they can access the full suite of web-based clinical risk management resources being made available by ECRI to you free on behalf of HRSA. This website contains risk management and guidance articles, sample policies and procedures, risk assessment tools, educational courses with CME credit, and other resources to help make your jobs easier so you can learn from others, customize to your own organization's needs, and not reinvent the wheel. You can read about all of the resources offered and log in from the web address listed on slide 3, and that is www.ecri.org/clinical_RM_program. An unlimited number of individuals at each organization can obtain user IDs to access the materials. If you have not yet activated your user ID, please let us know. Our email address, which is also printed on slide 3, is clinical_RM_program@ecri.org. And with your audio conference registration confirmation, you received an email link to the slide handouts for today's presentation. We hope you've had the opportunity to print or download the slides. Throughout this audio conference, we'll refer to slide or page numbers in the handouts so you can follow along. This is a continuation of our Brown Bag Lunch audio conferences, all of which are archived on the website if you missed them live. Audio conferences are also converted to courses for CME credit and are available through the website. If you have not yet obtained or don't remember your course keys to access these or other courses, please email us. We will have a question and answer session at the conclusion of today's program. However, keep in mind that this audio conference is not the appropriate place to discuss detailed, case-specific aspects of unresolved claims or litigation. Likewise, risk management information provided in this audio conference is not to be considered legal advice, and as with any information provided by ECRI Institute, it is intended as guidance to be used consistent with the internal needs of your organization. This information is not to be viewed as required by ECRI Institute or HRSA. Any detailed, fact-specific health center issues should be addressed to the FTCA helpline, and all questions regarding pending legal cases should be directed to your own organization's private attorneys. I'm now going to turn the program over to Madeline Quattrone. Madeline is a Senior Risk Management Analyst at ECRI Institute and serves as legal editor for our risk management publications and provides various consulting services to ECRI Institute clients. Before joining ECRI, Madeline was a partner in a law firm in New Jersey, where she defended physicians, hospitals, and other healthcare providers in medical negligence lawsuits. She was among the first women lawyers in that state to achieve certification by the New Jersey Supreme Court as a civil trial attorney. Also joining us later in the presentation during the question and answers will be Kathy Shostak. For those of you on some of our previous audio conferences, you may already be familiar with Kathy's expertise in ambulatory care risk management. Kathy is a nurse with 20 years of experience in healthcare risk management, the most recent of which have been focused on patient safety and medical error prevention. She has risk management consultative experience within the medical malpractice insurance industry and management experience at the corporate risk management level of a large multi-specialty physician group. And with that, I will turn it over to Madeline.
Thank you, Paul. Welcome, everyone, and thank you for taking time out of your busy schedule to participate in today's program. Slide 4 lists the learning objectives for today's presentation. In addition to providing information and strategies focusing on these objectives, this audio conference will also discuss an actual courtroom trial of a shoulder dystocia case. This is an interactive presentation, and at times we will ask polling questions for your input. Slide 5 lists some of the reasons why shoulder dystocia is a high liability event. It is among the leading reasons for lawsuits against obstetrics providers. Nearly half of claims result in payment to the plaintiffs, and multi-million-dollar trial awards are not unusual. Plaintiffs in some of these cases have sought monetary compensation for injuries to both the infant and the mother. In 2009, for example, a jury in New York State awarded $56 million to the plaintiffs in a shoulder dystocia case. A jury found that the obstetrician and the staff assisting at delivery failed to timely and appropriately address shoulder dystocia. The infant reportedly suffered nerve damage, internal bleeding, bruising in the cervical area, facial and upper arm bruising, and permanent damage to his brain stem. In another case, in 2008, a jury awarded $28 million in a shoulder dystocia case in which the infant sustained severe arm and spinal cord injury. And just this week, a jury in Iowa found an obstetrician liable for a brachial plexus injury. Commonly asserted allegations of negligence in these cases include failure to recognize maternal and fetal risk factors, failure to plan for a potential shoulder dystocia presentation, and failure to adhere to accepted standards in conducting maneuvers to relieve shoulder dystocia. What makes these cases difficult to defend is that the medical records often lack documentation that can bolster the defense of the delivering obstetrics provider. In fact, a study of obstetrics claims reported that in 54% of the cases in which payment was made, there was a lack of clear documentation of the events surrounding the management of shoulder dystocia. So, one strategy that can reduce the risk of litigation is to ensure that you record accurate and complete documentation of the events surrounding delivery. To reduce clinical and legal risk, you must be aware not only of the clinical factors associated with shoulder dystocia, but also the factors that are typically scrutinized by plaintiffs' attorneys, their expert medical witnesses, and the courts. Slide 6 provides a definition of shoulder dystocia taken from ACOG clinical practice guidelines. While shoulder dystocia may not be preventable, it can be managed to improve the outcome of delivery. So what are the most important common problems that obstetrics providers experience in managing shoulder dystocia? An interesting study of observations of 450 simulated shoulder dystocia deliveries identified these difficulties. Based on observations, obstetricians experienced poor communication, inability to gain internal access, confusion over internal maneuvers, and the application of excess traction. On slide 7, we see a list of maneuvers that the clinical literature indicates can be used to relieve shoulder dystocia. The objective of these maneuvers is to compensate for the incompatible fetal, shoulder, and maternal pelvic dimensions by changing the relative positions of the maternal pelvis and the fetal shoulders. There are no specific guidelines regarding the sequence of these maneuvers, but facilities and birthing centers may consider using a set pattern of steps that providers can follow during births and during interdisciplinary shoulder dystocia drills. Slide 8 lists maternal risk factors for shoulder dystocia. Shoulder dystocia cannot be prevented, and no accurate method exists to clearly identify maternal patients or fetuses who will develop this complication. Nevertheless, an important component of clinical risk management involves recognizing the clinical risk factors that are associated with shoulder dystocia. Maternal risk factors should be identified, assessed, documented, and considered in informed consent discussions with the patient when you and the patient are discussing plans for delivery. Planned cesarean section delivery is not a reasonable strategy for suspected macrosomia, according to ACOG, but ACOG suggests that planned cesarean section delivery may be considered in light of both maternal and fetal risk factors. On slide 9, we see a list of known fetal risk factors. With regard to macrosomia, the clinical literature indicates that ultrasound measurements to estimate macrosomia have limited accuracy. Although a planned cesarean delivery based on suspected macrosomia is not a reasonable strategy according to ACOG, a planned cesarean delivery may be reasonable for the non-diabetic mother with an estimated fetal weight exceeding 5,000 grams, or for the diabetic mother whose fetus is estimated to weigh more than 4,500 grams. So when these clinical risk factors are present, the option for a planned delivery section should be discussed with the patient in obtaining her informed consent to a delivery plan. In light of the high rate of diabetes among obstetrics patients seen in your health centers, you'll want to be alert to known fetal risk factors associated with that patient population. For example, macrosomic neonates of diabetic mothers are characterized by larger shoulder and extremity circumferences, decreased head-to-shoulder ratio, in other words, a large fetal chest relative to the biparietal diameter, higher body fat, and thicker upper extremity skin folds compared with neonates of non-diabetic mothers. Intensive treatment of maternal diabetes during pregnancy may reduce the risk of neonatal macrosomia and fetal shoulder dystocia, according to a number of studies. Slide 10 lists 3 intrapartum risk factors associated with shoulder dystocia. Note that a precipitous or protracted second stage of labor may signal a risk factor for shoulder dystocia. The second stage of labor is defined as beginning when the cervix is fully effaced and dilated and ending with the delivery of the infant. ACOG considers a prolonged second stage of labor for nulliparous women as the lack of continuing progress for 3 hours with regional anesthesia or 2 hours without regional anesthesia. For women who've had previously delivered, prolonged second stage is defined as a lack of continuing progress in a woman for 2 hours with regional anesthesia and 1 hour without regional anesthesia. Moving on to slide 11. Although shoulder dystocia is not predictable, it may be reasonably foreseeable in the legal sense of that term. If a harm is deemed reasonably foreseeable, the law imposes a duty to take steps to mitigate the risk of harm. So, translating that legal concept to clinical obstetrics, it is important for patient safety and for legal and risk management purposes to assess the risk of shoulder dystocia, thoroughly document the antenatal care record, and communicate identified risks so that an interdisciplinary plan can be made for delivery. The clinical literature supports documenting the elements shown on this slide, slide 11, with regard to maternal history, glucose screening, fetal ultrasound, and fundal height. Slide 12 lists the essential elements of shoulder dystocia risk management. Among the factors that plaintiffs' attorneys look for in the medical record, and this is why documentation is so important, is whether any factors that are associated with shoulder dystocia were present, identified and communicated to the patient and to the obstetrics team before delivery. Certainly from a clinical perspective, by communicating risk effectively, the delivery team will be better prepared to manage the emergency, and the mother will have had some time in advance of delivery to understand the potential complication and how it might be addressed. Proper management, of course, means adherence to accepted standards of care. The standard of care is defined at trial as what a reasonable obstetrician would do under similar circumstances based on what is known from peer-reviewed literature, professional organization guidelines, and expert witness testimony based upon the witness's knowledge, training, and experience. I can't emphasize enough that documenting your proper management is key to your defense. Of course, prompt recognition and treatment of any shoulder dystocia complication is not only good practice, it can mitigate damages. And finally, participating in interdisciplinary simulations, shoulder dystocia drills, not only can hone your skills, it also results in an effective team response to shoulder dystocia. And as we'll discuss in a little while, if you regularly participate in shoulder dystocia drills and you do end up in court defending your management of shoulder dystocia, you'll be better positioned to use the legal rules of evidence to bolster your defense.
Okay, let's break here for a second, and now to our listeners, it's your turn to participate. This is the first of 3 polling questions we'll be asking during the course of this presentation. This question on slide 13 focuses on whether your health center or clinic has formal shoulder dystocia education programs for your staff. The potential answers to these questions are listed again on slide 13. So if your health center makes shoulder dystocia education available to your obstetrical staff, please press star 1. If your health center is currently developing shoulder dystocia education for your staff, please press star 2. If your health center does not make shoulder dystocia education available to staff, we press star 3. Again, while you're responding, I just want to let everyone know that we will be making results of selected polling questions from today's audio conference available in the next edition of our biweekly Risk and Safety e-newsletter. The next issue will come out on Friday, July 29th, which is 1 week from tomorrow.
The voting has ended.
Okay. And Madeline, we can move on with slide 14.
All righty. Slide 14 begins our discussion of a medical malpractice trial involving an obstetrician who provided prenatal and labor and delivery care to a patient of an FTCA-deemed federally qualified health center. The trial took place in a United States District Court, and the facts of the case are taken from the trial judge's written opinion. The professional background of the defendant obstetrician included medical school training in a university outside the U.S., internship and obstetrics residency in the U.S., and the physician had been board certified since 1982. He had delivered approximately 5,000 babies, 25 of which were delivered after a shoulder dystocia presentation. The court also described the patient's obstetrical history. Her first pregnancy was described as uneventful with a normal vaginal delivery. Her second pregnancy, at issue in this case, was managed by the same obstetrician who had managed her first delivery and was described as uneventful until delivery. We chose this case to present to you because it provides a real-world example that the risk management mantra document, 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 something that you've heard so many times, can really make the difference in the outcome of a malpractice case. The lawsuit alleged that the obstetrician was negligent in his management of the delivery and that his negligence resulted in the infant suffering a preventable permanent brachial plexus injury. Through her attorney, the mother claimed that when the obstetrician was confronted with shoulder dystocia, he failed to perform appropriate obstetrical maneuvers and instead applied excessive lateral traction to the infant's head and thereby caused the child's permanent brachial plexus injury of the right side. Please keep in mind as we discuss this case that this infant developed a brachial plexus injury to her right side. What is remarkable about this lawsuit is its outcome. Unlike so many cases like it, it did not result in a multi-million-dollar verdict. In fact, the trial ended with the court reaching the conclusion that the obstetrician was not negligent in his conduct of the delivery and that his delivery method did not cause the infant's brachial plexus injury. The obstetrician's successful defense was mainly due to two factors. First, he was able to refute the allegations that he failed to conform to accepted standards of care. And he did this largely through adequate documentation in the medical record. And his documentation was also corroborated by nurses' documentation. Secondly, he was in a position that allowed him to use the federal rules of evidence to his advantage to explain to the court how he managed the delivery, even though at the time of the trial he could not actually remember the specific events that took place in the labor and delivery room. Slide 15 explains a few basic legal concepts. Lawsuits brought under the FTCA, the Federal Tort Claims Act, are tried in federal court. The federal rules of civil procedure are used to conduct the trial. The law that is applied to determine whether medical negligence occurred is state law, usually the law of the state in which the events occurred. Typically, the law requires the party bringing the lawsuit, that's the plaintiff, to prove a duty of due care existed between the defendant, person being sued, and the plaintiff, that the defendant breached that duty, and that the breach caused or was a substantial factor in causing the damage alleged. In an FTCA lawsuit, the judge presides over the trial without a jury. The judge acts as a legal umpire, so to speak, and applies the federal rules of evidence to determine whether testimony or records are reliable enough to be admitted into evidence. Because there is no jury, the judge also takes on the role of the jury. In other words, the judge acts as a fact finder and assesses the demeanor and the credibility of the testimony of the parties and the witnesses, including the expert witnesses. The judge determines what is fact by determining who to believe and what to believe and what weight to give to each bit of evidence presented by the parties and their witnesses. In order for the plaintiff, the party bringing the lawsuit, to prevail, he or she must demonstrate only a preponderance of the credible evidence. And that's much less proof than what is required in a criminal case, which requires evidence beyond a reasonable doubt. Slide 16 outlines the keys to the success of the obstetrician's defense that you should bear in mind throughout this discussion. Most importantly, he was able to refute allegations of negligence through credible documentation that was admitted into evidence. Medical records can make or break your defense. Medical records are treated as business records, and as such, they can be used at trial to refresh a witness's memory of the events that are recorded. On the other hand, if the court determines that the record or a portion of the record is not trustworthy or reliable, the record will not be admitted into evidence. And just as an aside, please be aware that knowingly creating false documentation in a medical record is not only unethical, it is a crime. Slide 17 summarizes some of the documentation in the medical record. Take a look at the documentation that appears on the left column of slide 17 and contrast it with the trial testimony of the maternal patient's mother that's on the right column of the slide. The maternal patient's mother was present during labor and delivery. The mother herself was not able to testify at trial. She had been admitted to a hospital for treatment of a schizoaffective disorder. However, she testified before trial in deposition testimony under oath that she remembered nothing about the labor and delivery because she'd been suffering from depression. Her pretrial testimony, limited as it was read into evidence at trial. The obstetrician also testified that he had no specific memory of this delivery. In fact, he was not even aware of any injury to the infant after delivery. So his testimony regarding the events of delivery was based on two things. First, the medical records that had been admitted into evidence, and second, the obstetrician testified about his usual habit, practice, custom, and procedure in responding to a shoulder dystocia presentation. The court allowed the doctor to testify about the steps that he routinely and habitually takes when he recognizes shoulder dystocia. So here's your legal lesson. The court applied a federal rule of evidence, it's Evidence Rule 406, that says, evidence of the habit of a person or the routine practice of an organization, whether corroborated or not, and regardless of the presence of eyewitnesses, is relevant to prove that the conduct of the person or organization on a particular occasion conformed with the habit or the routine practice. Well, that's a legal mouthful. Here's how it worked in this case. Because the obstetrician was board certified, had 30 years of experience, and had delivered 25 infants with shoulder dystocia presentation, the court found that he met the legal threshold requirement that in fact he had developed a customary practice that he habitually followed upon recognizing shoulder dystocia. The obstetrician testified that once he concludes that shoulder dystocia is occurring, it is his practice to direct the delivery team to perform the McRoberts maneuver and apply suprapubic pressure. Based on his customary practice, he testified that he placed his hands on the baby's head upon presentation, but did not apply any traction whatsoever, either upward or downward. He testified that he immediately recognized the turtle sign that shoulder dystocia was potentially occurring because the baby's head appeared to retract into the vagina. He placed his hands on the baby's head not once but twice, first when the baby's head initially crowned, and again after the proper maternal maneuvers had been performed. When he saw the turtle sign, he asked for help from the delivery team to perform the McRoberts maneuver. The mother was practically already in the McRoberts position, so accomplishing the maneuver took only seconds. It required merely, quote, adding more flexion to the mother's knees, unquote, by pushing them back while the legs were still on the stirrups toward the chest of the mother and a little bit outward. While the patient was in the McRoberts position, the obstetrician instructed the senior resident to apply suprapubic pressure in an attempt to dislodge the baby's shoulder from under the mother's pubic bone. While the senior resident was intermittently applying suprapubic pressure, the obstetrician remained standing between the patient's legs with his hands in front of him, waiting for the baby's shoulders to become dislodged. When he observed the intermittent suprapubic pressure beginning to dislodge the baby's shoulder and the baby's head moving further out of the vaginal canal, the obstetrician again placed his hands upon the baby's head and applied gentle, intermittent downward traction to the head for 30 to 40 seconds. He did not apply this pressure until after the mother was in the McRoberts position and the suprapubic pressure was being applied. The combination of these maneuvers, the McRoberts position, suprapubic pressure, and the 30 to 40 seconds of gentle, intermittent downward traction, successfully dislodged the baby's shoulders and enabled the delivery to proceed. He estimated that approximately 1.5 minutes after he first recognized shoulder dystocia, the baby delivered. His delivery note that he recorded about 15 minutes after the delivery read in part, quote, at the delivery of the vertex, I felt potential shoulder dystocia. The patient was placed in chest-knee position and suprapubic pressure applied by the senior resident and a baby girl delivered in ROA position crying. Infant was suctioned and handed to delivery nurse. I repaired episiotomy, APGARs 9 and 9, weight 10 pounds. Moving to slide 18. It is interesting that the maternal patient's mother, who was present during the delivery, testified about a period of time during delivery when everything went quiet. Her testimony is consistent with a mnemonic called Be Calm, shown on slide 18, which we tell the mother, breathe, don't push, elevate the legs to the Nick Roberts position, there's a call for help, the application of suprapubic pressure, enlargement of the vaginal opening, and then beginning the maneuvers. Slide 19 makes the point that clinical risk management is also effective legal risk management. By the time a malpractice case gets to the courtroom, witnesses from the healthcare team may no longer be available to testify and memories may fade. In this case, because the obstetrician himself did not conduct an exam of the infant after he quickly dislodged the fetal shoulders, he was not aware of an actual injury to the infant. And so there was no reason why he would have recalled the specifics of this delivery at all. If, however, the obstetrician in this case had not had the experience of managing 25 other shoulder dystocia cases, the court most likely would not have allowed him to testify about his habit or routine method of managing shoulder dystocia. So clinicians who do not have extensive or significant experience with shoulder dystocia should develop a habit of how to proceed by participating in repeated shoulder dystocia drills. That strategy is good for patient safety and good for your legal defense. If you can convince the judge that you have developed a routine, habit, and procedure for managing shoulder dystocia, the court is more likely to allow you to testify about it in the event that you need to fill in any specific gaps in your memory of the delivery. And by the way, almost all states have a similar rule of evidence about routine habit, custom, and practice. Slide 20 refers to a study published in the American Journal of Obstetrics and Gynecology in April 2011. A hospital in New York State implemented a mandatory shoulder dystocia training and practice program to simplify and standardize the management of shoulder dystocia emergencies. The training covered risk factors, early recognition, management, and documentation. And attending physicians, residents, midwives, and nurses participated. By applying a certain type of statistical analysis to the obstetrical data before and after shoulder dystocia training was implemented, the researchers were able to show that the training reduced the rate of brachial plexus injury. Slide 21 lists some of the reasons that may have accounted for a reduction in brachial plexus injury in cases of shoulder dystocia after the team training and drills were implemented. Essentially, the training supported effective teamwork and communication.
Okay, we'll pause here again, and for our second polling question, shown on slide 22, we'd like to know what position you hold in your health center or free clinic. Again, the potential answers are listed on slide 22. So if you're an obstetrician, please press star 1. If you are a nurse midwife, please press star 2. If you are a registered nurse but not a nurse midwife, please press star 3. And if you're another staff member, in other words, somebody who is not an obstetrician, nurse midwife, or other registered nurse, please press star 4. Again, I'll remind everyone that responses to some of the selected polling questions will be available in the next issue of the Risk Management e-News on July 29th, and also that we do have courses on obstetrical safety and liability available as part of the clinical risk management program. And again, we'll talk again about our contact information if you need more information about accessing those courses.
And the polling has ended.
Okay. And Madeline, back to you then.
All righty. Getting back to our trial, on slide 23, the question for the court to decide was whether the obstetrician acted in accordance with accepted standards of care. The law requires the party bringing the lawsuit to establish what the standard of care is. Well, how is that done? Judges and juries are typically not obstetricians, and so they need to be informed and educated about the standard of care. In court, the standard of care in malpractice cases is typically shown through opinion testimony from individuals who are deemed to be expert witnesses who will testify about their opinions based on their knowledge, training, and experience, and they are subjected to cross-examination by the attorneys for the adverse parties. Expert witnesses may give an opinion about the standard of care and also about the cause of an injury. In this case, obstetricians for the plaintiff and the defense gave their differing opinions, and the pediatric neurologist provided their opinions about the cause of the infant's brachial plexus injury. Slide 24 discusses a federal rule of evidence, Rule 803, that allows a party to introduce evidence of the standard of care through statements or guidelines or other information published by, quote, recognized authorities, unquote, and these statements can be read into evidence in the courtroom. A recognized authority, for example, would be the American College of Obstetricians and Gynecologists, and statements such as clinical care guidelines can be read for the court's consideration as some evidence of the standard of care. State rules may differ. Information from recognized authorities can also be used to bolster expert opinion testimony about causation and, as was done in this case, the causes of shoulder dystocia and brachial plexus injury. Slide 25 provides some information from the clinical literature about causes of brachial plexus injury. Slide 26 takes us back to our trial. Malpractice cases are sometimes referred to as a battle of expert witnesses. The plaintiff's pediatric neurologist expert witness testified that the infant's permanent brachial plexus injury was caused by applying excessive lateral force to the infant's head. The basis for his opinion was the fact that the child's brachial plexus injury was permanent. On cross-examination, he admitted that as a pediatric neurologist, the only circumstance in which he ever forms an opinion as to the cause of a brachial plexus injury is when he is being paid as a legal expert. He also admitted that it was, quote, definitely possible, unquote, for a permanent brachial plexus injury to be caused by something other than excess traction. He acknowledged reported cases in the medical literature documenting permanent brachial plexus injuries, even when there were no opportunity for the delivering physician or anyone else to apply excess traction to the baby's head. A defense expert witness testified that the cause of the brachial plexus injury was the combined forces of labor and impaction of the infant's shoulders against the mother's bone structure during delivery. He based his opinion on the obstetrician's and eyewitness testimony, the medical records, the post-delivery condition of the baby, the nature of the injury itself, and peer-reviewed medical literature which provides an alternative explanation for the injury other than the use of excess traction. That expert witness also explained that the nature of the infant's injury is inconsistent with the application of excess lateral traction during an ROA delivery. Remember, ROA was documented in the record. Because the infant delivered in the ROA position, her left anterior shoulder was stuck behind the mother's pubic bone and her right posterior shoulder was stuck behind the mother's tailbone. If the delivering obstetrician had applied excessive downward traction as alleged by the plaintiff's expert, the traction would have affected the brachial plexus on the infant's left side, resulting in an injury to her left arm, according to the defendant's expert testimony. But the infant suffered a right brachial plexus injury. The defendant's expert opined that it is therefore impossible for the obstetrician to have caused the infant's brachial plexus injury through the application of excessive downward traction. Slide 27 focuses on documentation. During the trial, the plaintiff's attorney pointed out that there was no specific entry in the record by the delivery nurse that the McRoberts maneuver was performed or that suprapubic pressure was applied. This was one area where record documentation could have been better. An expert witness for the defense had to help fill in the blanks, so to speak. He examined the medical record and found 2 contemporaneous nursing notes that stated that the obstetrician was, quote, assisted, unquote, by a resident physician during the delivery. The expert testified that for an uncomplicated delivery, no assistance by another physician would be needed or noted in the record. But for shoulder dystocia, an attending obstetrician would require assistance from others in order to perform the McRoberts maneuver and apply suprapubic pressure. The defense expert testified that the 2 separate nursing notes indicating assistance corroborated the obstetrician's contemporaneous delivery note. Had shoulder dystocia gone unrecognized, and if the appropriate maternal maneuvers had not been performed, the record would have no documentation of assistance. So the lesson here is that the better the documentation, the stronger your defense. You can see that the expert would not have had to fill in the blank, so to speak, had the delivery nurse specifically documented the application of McRoberts maneuver and the suprapubic pressure. In a nutshell, the lesson is be complete and be accurate in your documentation. Slide 28 states what the judge wrote about why he concluded that the defendant obstetrician was not liable for malpractice. In essence, he credited the accuracy of the contemporaneously documented medical record and found that the testimony provided by the obstetrician and his expert witnesses to be more credible than that of the maternal patient's mother and the adverse experts. In other words, the plaintiff did not sustain her burden of proof by the preponderance of the evidence. Moving to slide 29, we'll talk a little bit about communication. As you all know, communication failures can hurt patients. Communicating clearly with all members of the labor and delivery team requires speaking the same clinical language, particularly when communicating about obstetrical maneuvers and interpretations of fetal heart tracings. As a former medical malpractice defense attorney, I can recall several cases in which nurses documented that fundal pressure was used. Yet, when they were asked under oath to describe what they actually saw, they explained a maneuver that is in fact what is known as suprapubic pressure. As you can imagine, the discrepancy between what was recorded and what the nurses testified they saw was a significant legal hurdle that had to be overcome. Let's talk about communication with a patient. Poor communication with a patient can cause the patient to misunderstand the treatment plan, and that can lead to allegations of lack of informed consent. Poor communication with the patient or a member of the patient's family is often what triggers a malpractice suit. In fact, in this case, the patient's mother testified about her unsatisfactory communication with the obstetrician. And here are a few events that she testified about. Now, these events may seem relatively insignificant to you as providers, but they certainly were important to the patient and the family. During an office visit, the patient's mother asked the obstetrician to order a visiting nurse because the patient had been depressed. The obstetrician denied her request, saying that there was no obstetrical need for a visiting nurse and suggested a referral might be available from the psychiatry department because of the patient's mental health. The patient's mother testified that she felt, quote, very disappointed and hurt when the physician refused her request. Perhaps in this encounter, an opportunity was lost to establish a more effective rapport and communication with the patient and her family. The mother also testified that while the daughter was in labor, the obstetrician asked, "Who do you want to deliver the baby, the midwife or me?" And the patient's mother responded, "You," meaning the obstetrician, and she testified that she thought the obstetrician's approach by asking that question during the delivery seemed a little unprofessional. Third, the patient's mother also testified that there was no conversation with her and the obstetrician after the delivery. But she testified that the obstetrician simply told her there was a pull and that the baby should be fine in 3 months. Well, the obstetrician had no recall of this discussion, and he was not aware of an injury. And so it's possible that another provider spoke with the patient's mother. So it's important that in your discussions after delivery that you confirm that the patient and family understands what you're saying and that you document the gist of these conversations in the record. Moving on to slide 30, as we've seen, the court found the documentation in the medical record to be credible. Again, as a former defense attorney, I cannot overemphasize the importance of clear and accurate, complete documentation. Slide 30 lists elements that should be documented for shoulder dystocia. Use of templates for shoulder dystocia documentation can also be a helpful way to ensure adequate documentation. You can find one example of a template in the February 2011 issue of the American Journal of Obstetrics and Gynecology.
Okay, on slide 31, you'll find our final polling question for today's presentation. And we'd like to know how many individuals from your location are in the room listening to this audio conference. So if there's one person in the room, we'd ask that you press star 1. If there are 2 people, star 2. If there are 3 people, star 3, and so on. If you have 9 or more, you would press star 9. And again, I'll mention one last time that we'll be including results of this polling question in the next issue of our e-news coming out on July 29th. If you don't currently receive the e-news, it is emailed every other Friday. In just a couple slides, you'll see all of our contact information. Certainly encourage you to get in touch with us by email or telephone, and we'll make sure that you can begin to receive our biweekly risk and safety e-news.
And the polling has ended.
Okay. Alice?
All righty. Well, in addition to the sources that are listed on the bottom of your slides, slide 32 and slide 33 provides additional resources that were used in preparing this presentation. And with that, I thank you again all for attending today's presentation, and do remember, document, document, document. Thank you.
Okay, we'll open up the questions and answers then.
Thank you. We're ready to begin the question and answer session. To ask a question, please press star 1. You may withdraw your question by pressing star 2. Once again, ask a question, press star 1. One moment, please.
While the questions are queuing up, I do also want to remind folks that, again, as part of the clinical risk management program, folks at all the health centers and free clinics have access to online CME courses as part of our through our website, and they do include several courses on obstetrical safety in addition to dozens of other topics. So on the very last slide, you'll see our contact information, and if you are interested in getting access to those courses and you're not sure how, you can get in touch with us and we'll get you straightened out.
And at this time, there are no questions.
Okay. I will note that if anybody has a question that they don't want to maybe necessarily share at this time, again, you can get in touch with us. Our email on the last slide is clinical_RM_program@ECRI.org. As most of you know, this is actually, we've done this audio conference twice, and so we will make sure that the questions and answers from both audio conferences are posted on the website along with the archived recording of this audio conference. And certainly, if you want to get in touch with us by email afterwards, we'll be happy to respond to your questions in that fashion. Have we had anything queue up?
We have a question from Monica Ars. Your line is open.
I was wondering about presence of episiotomy versus no episiotomy in the case of shoulder dystocia. If there's documentation of enough room for maneuvers, is not doing an episiotomy going to be counted against you in court?
Oh, that's a very good question, which is really very clinical. It's going to depend on the facts and circumstances, your informed consent discussion with the patient, the reasons why an episiotomy was done or not done. The law does not dictate your clinical judgment. It's the standard of care that does. So if you can show what you've done and the reason why you've done it or not done it, then it's going to be up to the clinical expert witness testimony to inform the court whether that was the accepted standards of care. I'm not familiar with the clinical literature deeply enough to be able to tell you about any studies that may have addressed that. That may be a good midline research topic or something, but I don't have that information. But it's a very good question.
Yes, this is Kathy. I think the most important thing is to document your clinical decision making around whether a episiotomy was performed or not performed.
All right. Well, I guess we'll wrap it up here. And again, if you would want to get in touch with us afterwards to ask a question, our email address is clinical_RM_program@ecri.org. Again, it's on both slide 3 and the very last slide of your presentation. And so I will say thank you to everyone for your attendance, and we look forward to helping you out however we can.